let's bring in that analysis now, and that is with Elton Hart. A very good morning to you, Elton. Thank you so much for joining us. Interesting outcome. We were expecting an outcome either way, but the court saying that they reserve judgment.
No, indeed, the court has reserved judgment, but I mean the judgment has been reserved pertaining to the costs specifically, but the interdict has been granted. So the president has been given an interdict, so he is sort of half exempted from appearing on the 19th of January. And now also what has been said by the court order is clear, is that the former president, which is the respondent in the matter, cannot act on the summonses that was issued in December based on the nolli prosecute certificates that was issued until Part B of the application has been finalized.
So take us through that process of unpacking the nolli prosecute and how these two particular ones that were issued in this particular instance didn't carry weight in terms of bringing in the president as an accused.
Obviously, what picking up from what Judge Sutherland was alluding to, he said that the nolli prosecute certificates did not specifically name the president as a sort of have a person of interest in the complaint docket. So the NPA declined to prosecute Billy Downer and also Karen Moore, but it was not clear pertaining to Mr. Cyril Ramaphosa. Of course, we need to know no. And here it is that muddy situation where you have the president and Mr. Cyril Matamela. Can you actually marry these two? And that's where the process got a little bit muddied. But obviously, the judge also said that we'll have to now go to Part B. And if the NPA is afforded an opportunity to come and clear up why they issued the nolli prosecute certificates in a specific way to mention Billy Downer and Karen Moore, and not per se the president, but in the media statement or the statement that they released, they said the certificates pertain to everybody who has been mentioned in the affidavits and the complaint docket, the initial complaint. So that's where the NPA needs to come in. And the judge said they can only assert that fact if the certificates apply to the current president once they've heard the NPA also on that issue to come and clarify that issue. And I think that's why the judges felt like they should then give the current president the relief that he's currently seeking or that he seeked in the application.
So relief is granted, but the president is not off scot-free, is he? Let's just unpack all the 3 points. One is that the application is urgent. Two is that everything will be done pending the outcomes of the Part B, where respondent shouldn't continue to pursue the applicant, but also the point 3 saying reserved for decision at hearing of Part B. And you've already spoken a bit about all of these points, but let's just break them down one by one, starting with that the application is urgent. So it indeed was.
Yes, because what the judge said, he said specifically that because the court appearance of the 19th is on Thursday, it's imminent. So it is close and there's a threat to the freedom and liberties of the president. So that's why they had to see that there is urgency, because it doesn't matter. And I know that the advocate for the current president argued that even if your freedom is limited for 30 minutes, it's still a limitation of your rights. And the judges also agreed with that argument advanced by the current president's legal team, that there is an imminent threat and then there is urgency. The basis for urgency has been met. Then they also talked about was the grounds for the interdict met, and they also of the view, yes, that the grounds for an interdict was met. So that's where they moved from. And I think if one have listened to what the current president was arguing, they agreed with the judges agreed with the president's legal team.
Mm-hmm. Elton, Judge Sutherland took a lot of time trying to make the point of personal harm which was asserted by President Cyril Ramaphosa, saying that this was politically connected, and if he went to court on the 19th, it would have implications with him on the political front. And Judge Sutherland saying, well, personal harm we consider, but not really based on the point that you brought up, but based on the constitutionally guaranteed right to personal freedom. Break that one down for us.
Yes, but if one look at that harm, the constitutional right of freedom, one needs to check with it, and you have to check it in conjunction with everything. You can't look at it loosely. You have to look at it in conjunction with everything. And here's where I say that the CPA and the Constitution must be read in conjunction with each other. And although the Constitution give you, I believe there's also an echo in the lines. There's another interview running on this line. So I can't hear you guys clearly now in the studio.
Apologies for that. You can continue. I'm not talking.
Yes. So that harm that is created, which the president relies on on the Constitution, yes, that harm is there. One needs to just check, can that harm be limited? Is there justification to actually limit that right of freedom? And if there is grounds advanced by the respondent, which is the former president, that harm is not irreparable, it can be remedied at a later stage. They were supposed to then put it on the table and to say, this is how the current president can actually limit or repair that harm. And I could hear that the current president's legal team said that harm is irreparable. Once he's been forced to submit himself to the court proceedings on the 19th, they can never repair that, because there's also the brand of the president that needs to be protected. And that is where the court agreed with the legal team of the current president.
So why did Judge Sutherland find it important to stress or to mention the fact that the cost issue was highly debated?
Yes, it was, and I think it wasn't that highly debated, but it was a contentious issue. But I remember from the proceedings on Thursday that the current president's legal team, at the beginning of the proceedings, said in their papers they asked that the respondent pay the cost on a attorney-client basis, but they then changed and said they will just ask for costs on a party-party scale. Then the judge now said that because they're still Part B, they're going to reserve the cost argument or the cost judgment or the order for after the Part B has been heard. And I think they want to actually look at Part B and see, was it necessary for the former president to oppose the application of the current president? And then based on that, they will look at it holistically and make a order pertaining to cost. But I know that the current president only seek now an order on a party-party scale.
So what's the next move for former President Jacob Zuma and the next move for President Cyril Ramaphosa?
Obviously, the judge also said that the legal teams of the applicant and the respondent must go to the offices of the deputy judge president, to actually go and make arrangements so that they can actually deal with Part B. President Zuma at this point in time cannot do anything until they've dealt with Part B. Also, what former President Zuma can do is most probably he can appeal this decision that was taken today, because that's also one of the remedies that he has at his disposal, to actually set aside the order that was made today. But they will submit themselves to the deputy judge president so that they can make arrangements for hearing Part B and setting it down.
And what does it mean for proceedings on the 19th?
On the 19th, obviously, the president will not be there. They can most probably say that the matter is now postponed sine die. And obviously, you can remove the matter from the roll and institute it at a later stage. So there's various avenues that can happen. But on the 19th, it's only most probably Karen Moon and Billy Downer that will appear in the court if their case was remanded to that date. But President Cyril Ramaphosa, in his personal capacity as Mr. Cyril Matamela Ramaphosa, will not appear in court on the 19th.
Elton Hart, thank you so much for your analysis. Just as we recap, what are you saying is the decision that came out of the Johannesburg High Court this morning?
Today, if we recap, the decision is that Mr. Cyril Ramaphosa, either as the person or the president, is not appearing on the 19th, and that former President Jacob Zuma cannot proceed or take any further steps to further the private prosecution on the 19th until they have properly ventilated and an order is made in Part B of this current application.
Thank you so much for your analysis and your time this morning.